rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We are here for oral argument in case number CV210754, Premier Consulting et al. Versus Peace Relief et al. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. And counsel for appellee may reserve a portion of time for rebuttal to address only the cross-appeal issues if desired. The panel has read the briefs and discussed the case in conference. Judge Cruz is currently out of state attending a conference, a course on digital evidence for judges, and will participate in today's argument remotely. Counsel, you may proceed.
May it please the court, Timothy Berg of Fenimore Craig on behalf of appellants cross appellees. I would like to reserve 5 minutes for rebuttal. The primary issue in this appeal is whether JJSM Real Estate was obligated to credit Park's past due rent owed with excess rent JJSM received from its replacement tenant, and therefore whether the trial court properly reduced the jury verdict on this claim to nominal damages. The answer is no for several reasons. First, this case was submitted to a jury on a general verdict. And one of the things the jury could have concluded was that, in fact, JJSM terminated the lease at least when it entered into a new lease with a new client. If it is clear under both the language of the lease and the law that if the lease was terminated rather than possession, then Park isn't entitled to a credit on past due rent, either under the lease's language or the common law. What would happen is the lease would be terminated and Park would owe Premier rent for the period of time until the property was released.
There are two different remedies depending on whether your client decides to end the lease or to hold them to the lease but terminate possession. And at some point, did your client make that election, or I'm reading the brief to say that they don't have to, they can just do it at trial?
Yes, Your Honor, that is our position. If you read the case, and it's a Tempe development case, I think, written by then Judge McGregor, now retired Chief Justice McGregor, indicated that in a case like this, you can go to you can try inconsistent theories, and then ultimately you don't have to elect until trial. That's correct.
But what's your theory about the date? What's the relevant date where they no longer have possession, or whether and when the lease ended?
The date, our position would be that the date the lease terminated for purposes of paragraph 17.5 would be the date we released the property to a subsequent tenant. At that point, we elected to terminate the lease by leasing it to a new tenant.
So the date you released, or the date that lease became effective?
You're correct, Your Honor. The date that lease became effective.
But what
I wasn't drawing a distinction between the two, but that's a fair point, Your
Honor. And it wasn't clear to your client before then, where they hadn't said, okay, the lease is over. What if it takes 4 months to find a new tenant? At that point, is there a difference if the previous tenant is in possession or not?
I don't believe so, Your Honor. I believe under both the lease and the common law that if you have a lease and the tenant breaches the lease by not paying rent, then at least under this lease you're entitled either to take possession and lease it on the tenant's account, or you're entitled to terminate the lease. In either case, the tenant owes you the rent up until the new lease is terminated. That's what both 17.4 and 17.5 in the law say.
And I get the general argument about they have to pay the back rent, but in terms of asserting a right to a remedy under paragraph 17.2, I mean, there seems to be a condition that the landlord has to give notice that you're exercising this option.
What plaintiffs argued in the trial court was that we had to give notice. In addition to giving notice there in breach, we had to give that notice. What we argue for purposes of this appeal is two things. One, that because they had repudiated the lease, because they engaged in anticipatory repudiation, we no longer had to give notice. That their anticipatory repudiation excused our obligation to give notice, whether you do view it as a duty or a condition, and we cite.
But there's different options for you when they repudiate. I mean, you don't have to terminate the lease. You could continue the lease and just terminate possession. I mean, doesn't it make sense that you have to at least let them know which of those two you're choosing?
Not, Your Honor, when they repudiate the lease itself, no. No, I think when they engage in anticipatory repudiation as opposed to a simple breach of the lease, then then our obligation to provide that notice is excused. That's what the case law says.
But you're saying you're then proceeding under the terminating the lease provision, not the
Well,
you can remain in possession.
I think what we have is a right when they engage in anticipatory repudiation under 17.2 of the lease to pursue any of the three options. We could treat the lease as terminated. We could treat possession as terminated. We could try to enforce the lease. But what their anticipatory repudiation, including their surrendering their ability to run the marijuana property so that they couldn't possibly comply with the lease, does is excuses us from our obligation of providing notice. And in any event,
What was the date of their anticipatory repudiation?
I think, Your Honor, I don't have it right at hand. I'll have it for you when I come back up on rebuttal. But I think it depends on how you view it. But certainly if you view them, at the very least, I think they anticipatorily repudiated when they told us they were going to do that. And then they later put themselves in a position where it was impossible to comply by surrendering their authority to operate a marijuana facility. And so both of those operated as anticipatory repudiations, and those happened at two different dates.
But they initially told your client they were going to do that, but then I thought there was an injunction to keep them from doing it?
No, what the injunction did, I think, was keep them from doing certain things under the lease, but it didn't prevent them surrendering their authority. That's why they did that instead, because their way of getting around the fact that there was an injunction was to surrender their authority to operate the cultivation facility rather than to do something else under the lease.
So I thought in June 2017, at that point, Park hadn't cured, per Premier's May letter, and notified Premier, et cetera, that they were terminating the various leases. Is that correct?
Yes, and that would be
actual.
That would be an anticipatory repudiation.
Okay.
In addition, when they put themselves in a position where they could no longer comply because they surrendered their authority, that would also be an anticipatory repudiation. They did it twice. What the trial judge did here, I think, was basically ignore the provisions of the lease and ignore what we think is Arizona law, both of which require that, both of which would entitle Park to a credit against going forward rent for excess rent we got, but doesn't give them a right to get credit against back rent. And I think both 17.4 and 17.5 are clear on that in the lease, and it's consistent with the law of Arizona. The situation here really is the court is in a position on this issue of being asked to decide who should benefit if the landlord is able to go out and find a new tenant who'll pay more rent. And you have a choice. It can either be the landlord who went out, who bore the expense, who carried the property, who went out and got the new tenant, or it can be a breaching tenant. And we think under the law of Arizona, the answer ought to be that the tenant isn't entitled to a credit for excess rent because it's basically being given a benefit of its wrongdoing if you do that.
What, in your view, is the rationale or the flaws in the rationale of other states that have adopted a different approach?
Well, I think, Your Honor, just that. You have a choice between who's going to either bear the burden or get the benefit. I guess they get the benefit. And it seems to us that the states that say it ought to be the defaulting tenant instead of the innocent landlord are simply wrong. It's inconsistent with other provisions of Arizona law dealing with similar but other kinds of contracts. It's inconsistent with the majority view. And frankly, in a lot of the cases they cite, there's language in the specific lease that would lead a court to the conclusion you credit against back rent. And that's not true here. The lease here is pretty clear that if you default to 14.4 and 14.5, they don't get a credit for back rent.
But counsel, does 17.4 only apply if it's the landlord who terminates the tenant's right to possess?
I don't think so, Your Honor. I think it can apply in either circumstance. I don't know that it matters because you get to the same place under 17.4 or 17.5. And so even if, because they anticipatorily repudiated, we would look at 17.5 instead of 17.4, you still end up in a position where they owe us the rent until we terminate the lease, which is the date when we got the new tenant. So in any event, they owe us the back rent. What they don't owe us is the forward-going rent from the period of time we had the new tenant. And I think you get there under 17.4. I'm sorry, I don't mean to make noise by hitting the. You get there under 17.4, you get there under 17.5, you get there under common law. An additional issue is we had additional damage claims that the trial judge either didn't let us present or ruled against us on. And I want to just briefly touch those. The first one is we wanted to present evidence that we suffered a loss in the form of the marijuana inventory that was on the property. The court excused.
Does that turn on the business records?
It turns on the business records issue, exactly, Your Honor. And it's our position that Mr. Merrill and Mr. Artwell set forth a specific enough foundation to admit that record, that you don't have to have the person who wrote the record testify
do they have
to
to
it.
say something more than, I have no idea whether that's accurate? I'm making that up. But there is
I think what they would have to
some
say,
standard.
I think what they have to say is what they said here. We wanted these made, they were regularly made. This was part of what the arrangement was, that we kept these records. I don't know that they have to say, I made the record and I was there when the count took place, for example.
But wasn't the question to witness Merrill was, so who kept them and how were they kept contemporaneously with any event if they are an inventory record? Answer, I can't answer that. I don't know.
But I think Mr. Artwell tells you how they were kept or testifies to enough of that. Again, I want to move on to one more issue if I can, just quickly. And then I do want to save some time for rebuttal. The trial court also erred in failing to allow the jury to consider the lost investment in this case. There is evidence in the record that the appellants had invested money in this, that they lost that money as a result of this breach, and the trial court refused to instruct the jury on that loss. And we think that's an additional basis, one that should get us a new trial.
And is it clear that that's funds that are going for something other than land and buildings that they still own?
Yes, it is clear it is money that was spent putting the business up and running, getting employees, getting equipment, that sort of thing, Your Honor. Or certainly we should have been able to put evidence in as to the amount that was.
But was it specified in that? And you're saying that 5.4 has nothing to do with the land?
I'd have to go back and look, Your Honor. I know there was testimony that we invested money in it. I can't remember the degree to which it was broken down.
But you would agree that something like that would not be a damage? You still own
Well,
the property.
it seems to me that it would be possible for the jury to conclude, for example, that equipment we bought that could no longer be used, the inventory we had that would no longer be used, the money we spent training employees who are no longer working for us, all of that, anything that Premier no longer ended up owning would be, I agree, Your Honor. If you end up owning land, unless the land went down in value because of something that happened with the breach of the lease, the value of the land wouldn't be involved. I'm going to save my last 7 minutes for rebuttal. Thank you very much.
Good morning, Your Honors. May it please the Court. My name is Eric Frazier on behalf of the Appalese Park. I'm sure we'll talk about rent offset, which is the biggest issue in the case, but if you'll allow me, I'd just like to spend 2 minutes on the cross appeal, and I'd like to reserve a couple minutes for rebuttal on that too, because that's the simplest way to resolve the case. It allows the court to avoid the admittedly complex issue on the lease. The simplest way to resolve the case is for the court to hold that there was no evidence that a first harvest occurred in December 2016. And the reason is because this business never worked. It was a disaster. It seems like a convenient excuse to get us off the hook for rent, but it's the reality, because the entire point of this enterprise was to grow plants, get them onto retail shelves, and get them sold. If that had been successful, people would have been shouting from the rooftops. They would have been high-fiving and throwing a party and sending an email to the whole company saying, we did it, it worked. None of that is in the record because it never happened.
Are you saying there's no evidence to show that the cultivation facility achieved a first harvest by 2016? You're saying...
Right, that's correct. There's no evidence that a first harvest occurred by December 2016.
Then how do you explain the Schaefer email with pictures of blooming marijuana plants?
Because that's not first harvest. That is going from one room to another room, from a mother room to a bloom room, or vice versa.
But wasn't it up to JJSM to define what first harvest was based on the lease?
Well, that definition would have to be reasonable, but on appeal, there's no dispute over what definition controls. On appeal, we quoted from their own witnesses what they meant by first harvest. That's the definition we're adopting for our appeal. They have not disputed that in their answering brief on the cross appeal. So there's no question that one of the required elements for first harvest, even under their own answering brief, is that the plants have to make it to market. They have to make it onto retail shelves. And there's no evidence of that. And the cross appeal answering brief cites evidence, cites supposed testimony that said it made it onto retail shelves. But if you go look at those citations and pull those portions of the transcript, it's not there. There's no testimony that this ever made it onto retail shelves.
That's my very vague recollection, was that 10% of the inventory came from them. That's not accurate?
Well, certainly I don't think there's any evidence that any of it ever really made it onto retail shelves, at least by December 2016. And again, that's the only theory that the plaintiffs are advocating on appeal, is that by December 2016, a first harvest had occurred. That didn't happen. That was the theory at trial. The damages the jury awarded are based on December 2016. If there's no evidence supporting that, then there's no first harvest, and we have to reverse here. And again, I think that's the simpler way to address this case, because this is that rare case where if you look at the testimony that they're citing for the element that they acknowledge is a required element for first harvest, it's not there. So on the lease, I have a few responses to the plaintiff's arguments. I think right out of the gates, there is no termination here. 17.2 requires the landlord to terminate, not the tenant. And here, when we tried to terminate, JJSM came into court and sought a TRO and a preliminary injunction trying to prevent us from terminating. That is not consistent with a landlord who is intending to terminate the lease. Now, the lease specifically says that reentry and reletting does not terminate the lease. It says no such reentry or repossession, repairs, alterations, and additions, or reletting shall be construed as an eviction or ouster of tenant or as an election on landlord's part to terminate the lease, unless a written notice of such intention shall be given to tenant. Again, no such reletting shall be construed as an election on landlord's part to terminate the lease. So reletting did not terminate the lease, particularly here where we have a lease that requires written notice of termination. We have a landlord who, when we tried to terminate, went into court to seek injunctive relief, preventing termination. They don't cite any evidence of termination that the jury from which the jury could have concluded the lease was terminated. They didn't make that argument to the jury below. And if it was terminated, when? I mean, where's the evidence? And reletting alone, setting aside this express term in the lease that says that reletting cannot be construed as a termination. We know that reletting alone can't automatically mean there's a termination, because otherwise, the dozen or so cases that we rely on, all of which involve reletting the property, would have come out the other way. If reletting the property means the lease is terminated, then you would never get to the rule that we're relying on, which is that when you relet and the new lease has a higher rent than the old lease, you credit that to the defendant against the damages, including during the vacant period.
Counsel.
Even assuming we're not looking at damages under the contract and just under the common law. I mean, it still seems odd to say that you're going to credit surplus rents with the back rent that was owed while you were in possession, while your client's in possession. Why does that make sense?
Well, I mean, first of all, that is the majority rule adopted by most of the jurisdictions out there. And I think it flows directly from the common law principle that if a breach or a default enables the landlord to capture additional gains, those gains get credited back against the damages. That's the kind of default position. And the other common law principle that this follows from is the notion that you look at the original contract and you say, was there actually any harm here? Did the breach cause any harm? Because if you look at that period, that period for the full lease, the landlord was not actually harmed because during that period, the landlord would be made whole.
Well, how about
and then
if you,
some.
How about if you just released it for an amount that just perfectly covered the back rent and the rent going forward? In theory, at that point, the landlord has been made whole, but doesn't the tenant get a windfall for having stayed in the property for, they got to stay there for 5 years and they owed 5 years worth of rent? Why isn't that a windfall to the tenant?
Well, in this case, we weren't staying in the property, but again, remember the rent wouldn't start until after a first harvest had occurred.
But assume there was a first harvest and the rent is actually owed. Then at that point, it seems like it's a windfall to the tenant, not to attribute the excess rents. I completely understand prospectively that your obligation to pay rent for the next 3 years, and if you've leased it out at a higher rate, it should be an offset for that. But I'm struggling with why it goes to the back rent. A simpler example, some house you're living in, you got free rent essentially.
Right.
The fact that they can rent it out, it's not really sorry for not really asking a question.
No, I understand what you're getting at.
It's not really a windfall for the landlord from the standpoint that the landlord owns a property that's a certain value and is just renting it out at the fair market value. The windfall is to the tenant who didn't have to pay rent while they were there.
So maybe if the tenant was staying there the whole time, maybe that would be right. Here, either all or substantially all of this period, Park was gone. I mean, Park was gone, long gone. I mean, the new lease didn't start until 2020, so it was years of at least vacancy. We were not there. We were not capturing those gains of having the property. The period where we were there at the very beginning, the rent was abated because
you had the right to be there. Does that change the analysis for you?
And in fact, the lease was, I mean, you were supposed to pay, presuming that first harvest was in December. I mean, you were presumably supposed to pay from December 2016 to March 2020.
Right, but most of that period, I mean, either all or substantially all of that period, we weren't there. The locks had been changed. We were gone. I mean, the
So
ATO.
you're saying they removed your right to possession?
Yes, absolutely. And I don't think that's seriously in dispute here that they removed the right to possession. I don't think there was ever any argument to the jury that we had the right to be there during that period, and in fact, we were not there. But again,
I thought your argument, and please obviously correct me, under 17.4 was that they didn't remove your right to possess, and that's why they didn't comply with that obligation, and that's why that didn't apply.
They did not give written notice that they were terminating the right of possession. Did not give written notice that they were terminating the right of possession. But the common law rule is that when you terminate the right of possession but not the lease, you do credit that future rent against the damages. And that's true under 17.4 as well. Structurally, as we say in our briefs, the best way to interpret 17.4 is that you are crediting the future rent against the rent that is owed at that time.
And actually, I just want to walk through the timeline really quick. So
Sure.
Park notifies the parties in June 2017 that it's terminating the lease, correct?
Correct.
So you've let them know, or your client has let them know that the lease is terminated from their perspective. And I know later they go and get an injunction and whatnot.
Right.
So it's your position that having known that the park has terminated the lease, they're still required to provide written notice to Park.
Yes, absolutely. I mean, first of all, that's what the lease says. And second, there's no question on appeal now that everybody viewed that termination notice as ineffective. And so if there's an ineffective termination notice, where it's not only ineffective, but the landlord goes to court to stop it, absolutely, they still have to give written notice. Because the landlord is telling you, no, I'm not accepting this termination. the only reasonable conclusion is that the lease is still operative. And
What's the conclusion after you're locked out, though? At that point, isn't it pretty clear?
well, it may be clear that we don't have possession, but that puts you under the common law rule where, again, you credit the future rent against the damages. And that's really what's going on, is you're crediting the future rent against the damages, which is just an ordinary mitigation principle. And, mitigation is one of the strangest areas of the law when you're first learning the law, right? I mean, if you ask people on the street, hey, I signed a contract for $500 and I breached that, how much do I owe? Most people will say $500. But you ask a lawyer who's been through contracts class, they say, well, what did the seller get when they tried to resell, the asset? And in ordinary mitigation cases like widgets, we've gotten comfortable with this fact that even though in some sense it lets the breaching party off the hook, that's the efficient outcome. The efficient outcome is if the seller can get a higher price on the market, that's an efficient breach. It doesn't create any bad incentives if you credit the new price, the new damages, the new revenue against the damages that the plaintiff is seeking. That's just an ordinary application of the mitigation principles, which again, kind of at first blush.
Aren't you mitigating future rent? I'm still struggling with. I get an obligation to mitigate damages once you've locked somebody out. And now you've got an obligation to go and get a new tenant there. But I'm not sure why that translates to and let's excuse the rent that was owed before I locked you out.
Because these different options that the landlord has are really just different ways of allocating risk. And those different ways of allocating risk affect kind of the mechanics of mitigation. So upon a default, the landlord can essentially stop and go right into court and say, I want my money now. We haven't relet the property. And in that case, you still apply mitigation principles. You're just looking at what the fair market value is. Or the landlord can say, well, I'm not going into court right away, or I'm going to let this ride and I'm going to try to relet the property. And when you relet the property, if there's that vacant period, or the period between a default and reletting the property, there's a question of who bears that risk during that time, and who bears the risk of the new tenant paying less or paying more. And so again, the landlord at that point has two options. They can either bear the risk themselves, in which case they are terminating the lease and reletting for the landlord's own account, in which case they get all the ups if the rent is higher and they get all the downs if the rent is lower. Or they can keep the tenant on the hook, which is what they were doing here, keeping us on the hook, which is why they went in and got the TRO, to keep us on the hook. And at that point, if you're keeping the tenant on the hook, then the tenant bears the risk of if the new lease is higher, if the new lease is lower, that's the tenant's risk. But if the new lease is higher, the tenant gets those gains, and they're credited against the full amount of damages. That's why you have all of these cases around the country.
What's the best authority, though, for the full amount of damages, including back rent?
So,
while your client is still in possession, let's say it's a clean case of rent is owed, client in possession, there's some authority that says, that rent is also excused because you rented it out for a higher amount down the road.
So I'm not sure about the still in possession aspect, because again here, everyone has treated this property as essentially vacant because, at least for the vast majority of the time, it was vacant. And I don't think they've made any argument that the Superior Court should have sliced and diced this based on when it was vacant or when it was occupied. I don't think they've ever made that argument. But setting that aside, again, I think the best cases are Jack I. Bender, the Way versus the Ohio Center, Centerline, Dalamagus, La Casa Nino, Truitt. All of those cases, I think, applied the rent during the vacant period. And even if you look at this court's case from Lee Development versus PAP, the court reduced the damages in that case by the rental value, even though the unit was vacant, just in case the landlord ended up finding a new tenant down the road. And I know that case isn't on all fours here, but I think if you look at what they said there, they offset the fair market value against the full amount of damages, just in case the landlord later found a new tenant. That's mitigation at work.
Walk me through how your analysis would change if instead of reletting it for $70,000, it was relet for $20,000 in good faith.
So we would still owe the difference there, the discounted difference. That's the consequence of reletting it for the tenant's account.
So you would owe the past due plus the $13,000 a month for the remainder of the lease.
Yeah, I mean, I think mechanically what you would do is you would see what are the damages, you'd see what is the net present value of the new rent through the remaining period of the original lease, and you subtract that net present value from the damages. I think that's mechanically how you would do it. Because mitigation is just offsetting the damages. So I just want to make one quick point, which is that the options in 17.2 only apply when a tenant has defaulted. So this principle that an anticipatory repudiation, which I don't think was ever mentioned in the briefs, but that anticipatory repudiation excuses the landlord from having to give written notice under 17.2, that doesn't make sense because these options only apply when there's been a default. And so it makes no sense to say that you're excused from giving notice in a situation that only arises when there's been a default.
Because I thought the position, if we assume there was a first harvest, then they clearly have defaulted, they haven't paid rent. Is that not a default?
That is a default. And so I'm saying that when there's a default, that's the only time the landlord that's the only thing that triggers the options in 17.2. And so the plaintiffs are now saying in their brief that they don't have to give notice because their performance was excused by the default. But those provisions only apply when there's a default, so it doesn't make any sense to excuse them. Because then, when would you ever have to give notice if that were the case? If there are any further questions, I'd be happy to answer them. Otherwise, I'll save my last 2.5 minutes for a rebuttal on cross appeal. Thank you.
What I'd like to do is start with the cross appeal issue, because there was ample evidence from which the jury could have concluded there was a first harvest. At trial, Mr. Merrill testified that his understanding of a first harvest was when plants were grown and bloomed in the growing room, and he obtained that understanding from Mr. Schaefer of Park, and that Mr. Schaefer then sent him photos showing that the plants had bloomed and were in the growing room. That's enough evidence. It may well be that Mr. Frazier's client thinks that wasn't correct. It may well be that there was conflicting testimony. But that testimony in and of itself is sufficient to establish that there was a first harvest if the jury found that.
Notwithstanding, there's apparently no request or no demand that rent be paid at that point?
No, Your Honor. The obligation arises when there's first harvest, not when there's a demand for rent. And so what the jury had to find to hold Park liable for breach of the lease was that there had been a first harvest and therefore the rent obligation started.
And you agree that they could have concluded based on the fact that they never said, there's been a first harvest, we need you to start paying rent. You're just saying the fact that they didn't do that, it was up to the jury.
It was up to the jury. The jury had to decide whether or not there was a first harvest.
I thought there was notice sent. I thought a letter was sent to Park in February 2017.
Yes, there was. In addition, a letter was sent to Park indicating that we thought a first harvest had happened and that they owed rent. Thank you, Your Honor.
But you're saying it was 2016 was the first harvest?
December 2016.
That's with photographs?
Exhibit 45, I think, is Mr. Schaefer's email saying, here are the pictures of the plants in the growing room. We moved them to the other room, and here they are with their blooms. And the jury could have concluded that wasn't a first harvest, but the jury could conclude it was a first harvest. There was conflicting testimony on that point. Mr. Meisner and Mr. Merrill both testified that they understood that was the meaning of first harvest, and they understood it because Mr. Schaefer had told them that. Now, Mr. Frazier is going to get up here and tell you Mr. Merrill and Mr. Meisner don't know anything about first harvests, and they're not competent witnesses. But the point of the testimony isn't that they independently decided there was a first harvest. It's that they were told by Park what a first harvest was, and then they were told by Park essentially that a first harvest had happened because the pictures were taken. And that evidence in and of itself is sufficient to permit the jury to conclude that the first harvest happened and that the rent obligation began. Moving on to another point. Mr. Frazier suggests to you that if you look at 17.4, that it authorizes the crediting of back rent, of excess future rent against back rent. Please read that paragraph carefully. It is, we think, clear that it doesn't do that. It says we're entitled to our back rent and we credit excess future rent against rent to be done. If there's an ambiguity about it, then the only testimony in the record as to what it meant was Mr. Merrill's testimony that it meant you didn't have to credit against back rent. So they have no argument under 17.4 that they don't
You
owe
rely
rent.
on the sentence as owing as the same thereafter becomes due.
Yes. To us, that means that that was a credit against future rent, not past rent, because future rent isn't thereafter doing an owe. The ongoing rent is thereafter doing an owe. Evidence of termination. Prior to the trial, the judge found that termination versus possession, whether we had terminated the lease or terminated possession, was a question for the jury. Mr. Merrill testified that the lease was terminated. Park argued to the jury that we had terminated the lease. They cannot be heard, and that's cited in our brief. They cannot be heard now to argue there was no basis for the jury to find that the lease was terminated if they themselves argued that it was terminated.
What date was the termination?
That I don't know, Your Honor. I do know that they argued that the lease was terminated, and we cite the evidence in our brief. The next question about whether we lock them out and remove the right to possession and somehow breach the lease. What Mr. Frazier kind of glossed over was the lockout didn't occur when they were first in breach of the lease. They remained in possession for a period of time not paying rent they were owed. It was only after they canceled their approval to operate and so they could no longer operate that we locked them out. At that point, they had repudiated the contract by rendering themselves unable to perform. And if you're unable to perform, you've repudiated the contract and you're in breach of the lease. Basically, this case was tried to a jury. The jury concluded, one, that the lease was breached, that a first harvest had occurred, that Park had an obligation to pay rent and then hadn't paid it. The jury determined that under the lease, that Premier was entitled to all of the back rent. That's the amount of the jury verdict here. The judge erred in reducing that amount because both 17.4 and 17.5 did not give them a credit against future rent, and the common law doesn't. And again, I'm not going to stand here and walk you through all the cases on both sides. There's a lot of briefing on the common law in the brief, but in the end, it is consistent with Arizona law not to let the tenant benefit from its own breach. And what Mr. Frazier is asking you to do, however he dresses it up, is say, we breached the lease. We were wrong. If you find there was a first harvest, we admittedly breached the lease, and you want to let us off of our damages for that obligation because the landlord was lucky enough sometime later to rent the property for more. That's inconsistent with Arizona law.
The jury was instructed about the efforts to relet, and there's not a dispute as to, they could have got a new tenant in sooner.
Your Honor, I'm not aware of any dispute like that or any evidence that Park offered that we could have somehow leased the property sooner. I think the whole argument was once we leased the property and we were getting more rent, who got the benefit of that excess rent?
But did it go up through the point where Park was locked out, or was it just to when they repudiated the lease, in your view? I believe
our position was they owed us rent until we released, even if they repudiated. Again, damages for repudiation of a contract are still the contract damages. So even though they repudiated, they still owed us the rent under the lease going forward. And again, until the point at which we were able to mitigate.
Absent some claim that you delayed too much in finding it.
And I'm not aware of that claim. Thank you, Your Honors.
Thank you.
Very quickly on the first harvest issue, just to clear a couple things up, there was no letter in February 2017. And in terms of the testimony from Mr. Merrill and Mr. Misner, that testimony only showed that the plaintiffs had just declared a first harvest. It did not purport to be evidence the elements of first harvest had been met, including getting product to market. And the photos from that one email in the record show only a very early step in the process. There's no question on appeal and no dispute that those photos don't show that anything ever made it to market. And again, on On appeal, if you look at the plaintiff's cross-appeal answering brief, they do not dispute that to show that a first harvest occurred, they needed to have evidence that product made it to market, made it onto retail shelves, and there's no evidence of that. These photos don't work.
Define.
What's that?
I thought plaintiffs got to define first harvest. Am I misremembering? You're saying there's something in the record that shows that it had to reach the shelves?
That was the definition that the plaintiffs offered at trial, and we quoted that definition in our briefs, in our cross-appeal opening brief, and then the plaintiff's cross-appeal answering brief adopted that definition from their own witness, and never disputed that they needed to show that product made it to market. If they disputed that definition on appeal, they needed to say so.
That was presented to the jury?
Yes.
And I understand that it seems like a pretty good argument that there wasn't a first harvest, but it seems like if there's just a little bit of evidence and you present it to the jury, it's hard to reverse what the jury decided on that issue.
I agree that if there's a little bit of evidence on every element, but there's no evidence on making it to market. There's none. And if you go back and look at the citations in the cross-appeal answering brief where they claim that a witness testified that a product made it to market, it's not there. And since I have 20 seconds left, if you'll indulge me, my favorite issue in this case, but probably no one else's, is nominal damages. This seems like a trivial issue. It's really not. It gets to the core principles of civil procedure, which is that a court cannot add damages not found by a jury without going through very exacting processes. Thank you, Your Honors.
Counsel, thank you for your arguments today. We will take this matter under advisement.